Hi everyone, thanks for coming. My name's Justin. I'm the Acting Managing Principal Solicitor at Marrickville Legal Centre, and part of my practice is the Civil Law Service, which is quite broad, but a big part of our practice is motor vehicle accidents and often helping people who are uninsured and not at fault, which is what today is about. Before I get started with the formal presentation, I just want to acknowledge country that we're on. So I'm hosting this education session from the lands of the Gadigal people of the Eora Nation and acknowledge the traditional custodians of the various lands on which we are all on today and any First Nations people in attendance, and pay respects to elders past, present and emerging, and celebrate their ongoing cultures and connections to the lands and waters of New South Wales and Australia. Just some formalities. This is not specific legal advice. It's not a substitute for legal advice. So essentially today's general legal information about motor vehicle accidents and what uninsured drivers can do when they're not at fault, especially when dealing with either an insured driver or an uninsured driver. If you do have a specific legal problem and you do want some help, you can always contact us for legal assistance and we will take down your details and see whether we can offer you specific legal advice. Before I get started, actually feel free to ask questions in the chat and just disrupt me. It's supposed to be interactive today, so if you have any questions about any of the slides or you're curious about something when I'm discussing it, feel free to just put it in the chat and I'll stop and I will do my best to answer your question. Okay, so we'll just start generally with what your rights and responsibilities are as an uninsured driver that's gone through a motor vehicle accident. So that will cover what do I do at the scene of the accident? What if the other driver doesn't stop and does a hit and run? How do I know who's at fault? And should I report the accident to the police? These are kind of common questions people ask us when they come to our service. So here's a list of the kind of things you need to do at the scene of a car accident. So if you are in an accident, I hope none of you ever are, write down the information about the other car and the driver, including their name, full name, their address, and their registration details. Get any details from any witnesses that may have seen the accident, get their name and their number. Take notes about what the circumstances of the accident and any damage to your car. That includes taking some photographs, preferably on your phone so that they're dated and coloured. And if you can, drawing a diagram of where the accident happened and how it happened, and date and sign that. You should note the time of the accident, the place, whether it was day or night, what were the traffic conditions like, was it raining, was it sunny, anything else you think may have contributed to the accident happening. Now, if the police attend, they will speak to you and any witnesses, but we'll discuss when police generally do attend and when they don't. Some handy tips for you if you are ever in a car accident. So all drivers should stop and give their contact details, insurance details, license and car registration numbers to the other driver. They should take photographs of the front and back of the other driver's license to ensure that you have the current address. And police should only be called in some circumstances, such as if a person is injured or trapped. Now, we hope this never happens, but if another driver doesn't stop after they get in a car accident with you, there may be some issues. So try and take down the other driver's registration number if they do a hit and run. I know it can be very hard in the actual circumstance. Report the accident to police within 24 hours. The police can often attend and investigate situations where an accident has occurred and the other driver has failed to stop. And they can also investigate whether the other driver has given you false information or is refusing to provide you with their details. Now, in the worst case scenario, if the police will not or cannot provide you those details, but you've obtained the registration numbers, there's processes you can follow with Transport New South Wales to find the detail of the vehicle's registered operator. That's a pretty lengthy process and you would need specific advice on what that looks like. How do I know who's at fault? This is kind of the most common question we get at the Legal Centre, and more often than not, it's actually quite difficult to determine whether you are at fault, you're not at fault, or you're partly at fault. So the general rule is the person who was negligent and didn't take reasonable care while driving is the party that's at fault. It's not always easy to decide who's at fault in a car accident. Sometimes you could both be at fault, and we call that contributory negligence. In some instances, it could be a faultless accident, quite rare but possible. And the best way to decide who's at fault is at a later date. So take notes of your version of events and the evidence, collect your evidence, including witness statements and any relevant dashcam footage, CCTV footage that might be around where the accident happened. And then you should seek legal advice about your particular case. It's not particularly beneficial after a car accident to discuss who's at fault with the other driver after you've both just gone through something which has probably caused you a bit of shock. And one party saying, yeah, I'm not at fault, or yeah, I am at fault at the scene of the accident is not necessarily an admission for later legal proceedings that they are at fault. If you own your car, but you gave it to someone else to drive, you could be responsible if the driver is your agent and your driver was at fault. Now, the driver shouldn't admit fault at the time of the accident, as it could affect the case. It's quite limited in that you need to have some kind of control over how the person is using your car. For example, you said, yeah, you can use it on this date to do this. And that's what we call agency. So just go to the next slide. Okay. Now, should I report the accident to the police? You must report it to police if one or more drivers was intoxicated, someone has been injured, one or more of the cars had to be towed away, or the other driver did not exchange their details with you. If it's any other kind of scenario, typically you do not need to report the accident to the police. The next thing is insurance. So is the other party insured? So remember this presentation, is for uninsured drivers. So if you have comprehensive insurance or third-party property damage, may not be relevant to you. So we're assuming that you're uninsured, and the question is the other driver insured that has caused an accident? So different outcomes will apply depending on the insurance status of the other driver that hit your car. So these are the two scenarios. We'll consider whether you are not at fault and the other party is uninsured, and you are not at fault and the other party is insured. So just quickly, there we go. So if you're not at fault and unfortunately the other party is uninsured, the first thing you need to consider is, who am I pursuing? Can't pursue an insurance company because there is no insurance company. So it's a dispute between yourself and the other person who is driving the car. And in some circumstances, if the driver's not the owner, potentially the owner of that car. So if you find out the driver and the owner are not in fact the same person, you will need to seek some legal advice on that, because it does depend on the principle of agency we were just discussing a little bit before. I'm just going to wait because I can see Tommy typing, so I might just give him an opportunity.
Tommy, you're more than welcome to unmute your microphone and ask the question as well.
Sorry, I think it appears to be typing, but I didn't do anything, so.
Oh, good. That's okay, thanks. Now, if you're not at fault, what are you entitled to after an accident? It does depend, but generally you should be put back in the position you were in before the accident. So it's almost like pretending it never happened. So you get the reasonable cost of your repairs or the market value of your vehicle, whichever comes out to be less. If your car had to be towed, you're allowed to claim the reasonable towing costs. And in some circumstances, you can claim things like hire car costs, lost profits for income earning cars. Those costs must be reasonable, and you must act reasonably to mitigate your losses. So what I normally recommend before you go and spend money on hire car costs is to get advice, because sometimes the advice might be that a hire car is not reasonable for this length of time, and the court may not find that cover you for all those costs. If the other driver is uninsured, when should I pay? If you have the means, you can pay for the repairs yourself and recover the money from the other driver after the repairs. You need to keep accurate records and receipts in writing as evidence. You have to prove to the other driver that your repairs are fair, they're reasonable, they're not excessive, and that the repairs you've done to your car are only repairs that are related to the accident, not things that were unrelated to the accident, because the other driver may come back to you and say, I hit the back of your car, why are you claiming the front bumper? It has nothing to do with the accident, so I'm not going to pay for those costs. Now, if you can't afford to pay for your repairs, and often they are quite expensive, you can choose to recover the costs from the other driver before you actually do any of the repairs. And then any money recovered, you can use to pay for those repairs. We often suggest people try and get more than one quote from different mechanics to show that the amount you are going to be claiming is not excessive and is fair and reasonable in the circumstances. Now, the hire car costs we just discussed, as I said, in some instances where you're unable to drive your damaged car, you might be entitled to a hire car cost to be recovered, but you need to show it's reasonable. And that means, does the hire car reasonably meet my needs? Is the amount of time I've used the car reasonable? You know, if it's a minor accident where your bumper is damaged, it would be unreasonable to have a hire car for 2 months, because it should be fixed fairly quickly. As I said before, it's quite important to seek legal advice before you actually spend money on a hire car. You need to be careful after car accidents. Often towing companies will show up, or they're waiting, and they may try and tow your car and tell you to meet them at their towing company, and then they have associated crash claim companies that offer you a hire car. I highly recommend that you do not sign any agreements with those types of companies before you seek advice. The terms and conditions in those contracts are not favorable often to consumers and clients, and often there's a provision there that they're able to chase you for the hire car cost if they can't get it from the other side. So be very, very careful when that happens. Now, you've got your quote, you want to repair your car, so how do you ask the other driver to pay? So as you've got your quotes, you then need to communicate with the other driver, and we normally recommend that you write what we call a letter of demand, which sets out what happened, what day it happened, that you were the owner or driver, and that you hold them at fault, and that you request that they pay you a certain amount of money based on your quote, and you give them a reasonable period of time to respond. We normally recommend 14 to 21 days. And then hopefully they do respond. Sometimes they don't, and you might decide to send a second letter of demand, but there are other options which I will discuss soon. In our experience, when a client that's uninsured sends a letter of demand to another party that's also uninsured, they may come back and say, we can't afford to pay what you're claiming, or they might come back and say you're claiming too much. So they might offer to pay some of your quote, but not all of your quote. And that's where you need to make a decision. You need to consider whether you accept their offer. For example, they might say, I can pay half of this, but I can't afford to pay the whole amount. You'll need to consider whether you're going to accept that offer and say, yes, I'll accept half and we can just walk away and the matter's finished. Or if you reply and say, no, I want the full amount, and you continue to demand that amount. If you do settle the matter, so you agree that, I'm happy to accept 50% of the quote from the other side, then you usually should sign something, usually a deed or a term of settlement or a consent order, short little page that says the details of the accident, a statement noting what they're going to pay you and when, and that it's informed final settlement of each claim. And what that means is, in the future, you can't bring a future claim against them, and they can't bring one against you. So the matter's finished and the legal problem's done at that point, and it can't be reopened, essentially. Sorry. In some situations, you'll send a letter of demand and they'll ignore it or not pay. As I said just before, you can send a second one, or you can choose to mediate at a place like a community justice centre, which offers free mediation to try and settle the dispute without spending time and money in court. Mediation's free, it's impartial, it's confidential, and often matters tend to resolve at mediation if both parties come to the table in good faith. If mediation's not successful, or you say, I don't want to mediate because the other side's being hostile, or I don't feel safe mediating, or their conduct has not been in good faith, you can go straight to the local court for a motor vehicle accident. Anything under 20,000 is in the small claims division via a statement of claim. Before you lodge in court, you obviously want to consider the stress that might have, the delay, the costs associated with legal proceedings, and decide whether these factors are justifiable in relation to the amount you're claiming. And you need to get advice. You need to make sure the statement of claim is drafted properly. you then need to ensure it's filed properly and that it's properly served on the other side so that you don't have issues later down the track. Now, when you serve a statement of claim or when you file and serve it, the other side does have 28 days from the day it's served to respond. They may file a defence, and if they do, then it will go down the track of the court proceedings. They may respond by asking the court to pay by instalments because they can't afford to pay you the full amount. And that means the court will assess whether the payment plan they're offering is reasonable. They might do nothing, and that happens quite often. So they might fully ignore your statement of claim after it's served. And after 28 days have passed, you would then have to consider your next steps. And what we normally do for clients is obtain what we call default judgment. And that means I've applied, they've ignored it, I want judgment in my favour. You fill out the forms, the court will make the order if they're satisfied it's been served and the other side has simply not responded. And that's where it gets a little bit tricky, because even if you succeed in getting this judgment, the other party may be ignoring the claim because they have no means to pay it. And then you'll have to go through the process of what we call enforcement. And parties have 12 years to try and enforce a judgment to get money. Unfortunately, sometimes you end up spending fees, filing fees and service fees for the court, and are unsuccessful in obtaining money from the other person, maybe because they have no assets, maybe because they're in severe financial hardship and they can't afford to pay, or they're simply just ignoring everything. And it's hard to locate where they are or where they've moved to. Now, if you're going to go to court, you've got 6 years from the date of the accident. As I said, small claims is generally where you'll be for a car accident, unless it's a very severe thing where the costs are above 100,000. So all I can recommend really is to seek advice from us or from your relevant community legal centre or legal aid before you lodge your statement of claim, just to ensure it's done correctly and that it's not rejected by the court, or they ask you to amend it later, which can complicate things a little bit for you. Right, so now we're going to move on to if you're not at fault and the other party has insurance. Okay, so the other side may not claim on their insurance. And it's a common misconception that they have to, but unfortunately they don't. So they may have insurance, but they may decide, well, I don't want to pay, the excess, or I don't want my premiums to go up, so I'm not going to claim on my insurance policy. I'm just going to deal with it as an uninsured driver, essentially. So if that's the case, then you go back to everything I just said, and you have to deal with it directly with the other side on the basis that they're essentially not insured. More often than not, though, people, if they're insured, they'll claim on their insurance. And when that happens, the insurer will step into the shoes of the other side. And what that means is you no longer communicate with the other driver or owner. You're now dealing directly with their insurance company, because that's why they've paid for insurance. Now, the insurer will not pay for damage to your car unless that policyholder claims. Will their insurance cover your damage? It depends. So where the driver has insurance and they've claimed, there's a lot of factors we have to consider. So the type of insurance they've taken out and the extent of their liability for the damage to your car. If the other driver's insurer does admit fault, you are then entitled to receive the compensation we discussed before. So the reasonable costs of repairs or market value, whichever is less, towing costs, and any relevant higher car cost, loss of profits from the insurer. More often than not, insurers might ask you to assess your car. You should not automatically give it to them. You need to check the terms and the scope of why they want to assess your car. If there's a risk that your car will be written off and you don't want this to occur, you should refuse access to the insurer to assess your car. And there's no obligation on you to actually give it to them, the other side's insurer, that is. A big issue our clients face is the other driver is at fault. They've claimed on their insurance, but there's now a dispute with the insurer and the other driver, and that the insurer is not covering the cost. So when a party claims on their insurance, they need to satisfy their policy before the insurer is going to pay. So if the other side's breached their insurance policy, for example, they were underage, they were drink driving, they fail to pay their premiums, or they have not paid their excess, then you might be in a position where they've given you their insurance details, you've contacted the insurer, but the insurer says we can't proceed at the moment because we're dealing with our client who has not satisfied our policy. That puts you as a not at fault uninsured driver a bit in limbo. You could choose to then continue chasing the other driver individually, or if it's an excess issue, you should seek legal advice, because there are certain things you could do to try and get around waiting for the insurer to have the other driver pay their excess. More often than not, though, for our clients, there's always a dispute as to fault with the insurer. You often get letters from insurers, and they're kind of template letters that say, there was a car accident on this date, this time, and our client says you're at fault. Even if you believe you're completely not at fault, more often than not, they'll write to you and say you're at fault. Those letters should not be ignored. You should reply to them, particularly if you're not at fault, giving your version of events, denying liability, and saying that their client's at fault and these are your damages that you want them to cover. That will go back and forth for quite a bit of time. So often they'll send you another letter saying, we still think you're at fault. And you can reply back and say, well, I still don't think I'm at fault. So you can go through that negotiation. If the dispute can't be negotiated and settled, then either you or the insurer might decide to lodge in court at any point. Let's say the insurer lodges and you disagree, you would have to file a defense, and you would also file a cross claim against them for your damages, because you're saying you're not at fault. Before you go to court, though, there is what we call the Australian Financial Complaints Authority. Works similar to an ombudsman and deals with car insurers. If they're a member, most of the major ones are members of AFCA. Now, to access the Australian Financial Complaints Authority, the other side has to claim on their insurance. You would have to be uninsured. You would have to show that you're not at fault, and you would need to be only claiming damages that are less than 15,000. So it's quite limited. It's for uninsured drivers in those certain scenarios, and the Australian Financial Complaints Authority is good because it's a method of what we call alternative dispute resolution. So it's trying to avoid court and litigation and the complexities of the local court and legal costs and filing fees and service fees by trying to deal with it outside of court through a dispute resolution body. It's a free service. There are time limits, so if you are thinking of doing that, you do need to obviously seek legal advice before you decide to lodge that claim. Now, we'll just summarize a little bit. So what we've covered is what you do at the scene of the accident. What if the other driver does not stop immediately following the accident? How do I know who's at fault? Should I report it to the police? And is the other driver insured? And if so, what do I do? Now, as I said, this presentation was only for uninsured motorists who are not at fault. It's not legal advice. So if you're an insured motorist, the advice is completely different, and you can call, as I said, your local community legal centre and seek advice. Or if you are uninsured and at fault, you should definitely be seeking advice from your local community legal centre, because you should be getting advice about how to deal with insurers when you're uninsured and at fault, but you might be in financial hardship, for example, which is more often the case than not. So most insurers have what we call a financial hardship policy that can be applied. So it's important to seek advice in those situations as well. That's all for my presentation. I know it's only taken half an hour. It's a pretty niche subject, but I will open it up for any questions people might have or just comments. I can see Tommy has their hand up.
Yes, now this time, yes, I do have a question. Thank you for the good presentation, very succinct, but it's a lot of things to cover. But anyway, my question is that you mentioned that if the other person is uninsured but at fault, and then if they don't really pay for them because they look at it and we can't chase it up where they are, then what kind of penalty would that be happening for the other person that, let's say they're relocated to somewhere, and then is there any authority can just follow them up whether they were under the court case or they are on the way of all those car accident cases?
So are you, just so I understand the question, are you talking about after you've got an order from the court that allows you to get money from them?
Yes.
Yeah.
Yes.
Yeah, so there's processes in the local court of what we call examination. So it's very hard if you don't have their address, but if you have emails, other forms of contact like Facebook, other social media, there's what we call substituted service, which allows you, if you can't find someone through their postal address, it allows you to serve it in a different way, a less formal way. Now, there are ways to find people. As I said, after the car accident, if there's a hit and run, you contact the police. Police usually within 24 hours will chase up the other driver if you've got their rego number. There's requests you can make with Transport New South Wales if you've got the rego number. There's the searching of the Australian Electoral Commission roll. I mean, in some cases, people go so far if there's a lot of damages as getting a private investigator to find people. But that's obviously an extreme situation. Now, if you've got their details, but they're just ignoring the court, you can, and you've done what we call an examination notice, which is sending them a notice saying, please tell me, how much, what your finances are like, what your assets are like, what your debts are like, so I can understand your financial position, and they ignore that. You can apply to court for an order that they must attend court and answer questions about their finances, and if they don't show up, the court can get a warrant to get them to attend the court.
Okay, that sounds okay. Then sorry for another question, but let's say even if I'm not at fault, but the other one is at the fault but run away, then let's say I have to hire the solicitors and whoever to just help me for going through it. Can I just put the cost of hiring a professional against the others? If yeah.
So not you don't. What I suggest is you get advice from your community legal centre first, because it's a free service, and they will give you advice for free, so you don't have to pay for those solicitor costs. And then often the local court small claims is really designed for self-representation. You don't need a lawyer, and often people that get a lawyer might spend too much money compared to the value of their claim. Costs are capped in the local court small claims, so there are some costs you can claim, but they're unlikely to cover the amount you might spend on a private lawyer for a car accident completely. Okay. So you might get, if you're successful, you get some back, but maybe not all. It depends on how much they're charging you. But it's designed to be, fairly. It's hard, but if you've got a community legal centre or legal aid giving you advice or assisting you with the forms, more often than not, people can self-represent and avoid those extra costs that they may not fully recover.
Okay, sure. Thank you.
Not a problem. Any other questions?
You're very efficient, Justin.
I know.
So what I might do, while you may be thinking about the information that Justin had just presented, and if you have any questions, I'll pop into the chat. So we do have a little bit of a quiz, and this might prompt you to ask some questions. So we have a little bit of a quiz to test just the knowledge and the key points from the presentation, the real key takeaways that are important to know for this topic. So if you click on the link in the chat, you'll be able to go straight to the quiz. There'll be a couple of questions in there, and hopefully that's useful information for you to know, to take away from this session. But also if it does prompt you to ask any questions, please do, because we are well ahead of time, so we've got some time left for Q&A. And while you're doing that too, as you may know, we at Marrickville Legal Centre, this session is part of a series of legal webinars for Law Week. So this week is Law Week, and Law Week is all about promoting the law, ensuring that the community and clients are aware of their rights. And so this is just one of 10 different sessions that we're running throughout the week. If you're not already aware of the other sessions, I'll just pop into the chat the Law Week website. And there are other organisations that are running different events and webinars and other such things that you could register and attend throughout the week. And I think maybe into next week as well. So I'll pop that in the chat if anybody's interested in finding out a bit more about Law Week and the different events taking place. Also, in case you missed it, Justin was talking about the writing a letter of demand to the other party. So we actually have a session on how you can write and some tips and tricks on writing a letter of demand. And then on the flip side of that, responding to letters of demand. So I put the registration link into the chat. If that's of interest to you, then you're more than welcome to register and attend that session tomorrow as well. Or as Justin said, you can always reach out to us. I'll pop our website in the chat too, but we have our contact form on the website. There's also our number if you wanted to call us directly. We also have a legal chat bot. If you don't want to pick up the phone, you can always speak and chat to us via that legal messaging tool. It is a chat bot, so it would be automatic responses, but through that we can reach out to you to provide you with advice regarding your legal matter. And while I'm on a roll, one more link. I just, as you know, this is one of a series of CLEs, community legal education or legal webinars that we deliver. We also do this outside of Law Week as well. So to help us continually improve our presentation and the content and how we deliver these webinars, please, if you don't mind, we'd really appreciate if you can complete the feedback form. That really help us to continually improve our services into the future to better assist the community. So